Morning, everybody, and welcome to the Maryland Apex Accelerator webinar on this very hot day. Glad you could join us. Hopefully you are all staying cool. I'm your host, Yasmin Razak, and I'm the Marketing and Training Coordinator here. Today, the topic is very popular, so glad to see a great turnout from everybody. And it is the SBA and DOD or Mentor Protégé programs. And it is led by Richard Arnholt, who is a member at Bass, Berry and Sims, a law firm in DC. And he is joined by Adam Briscoe, who is also an associate at the firm. We will get started very shortly, and there will be opportunities for you to ask both Richard and Adam your questions by typing them in the chat box on your screen. We will answer as many as we can by the end of the webinar, so please do stay tuned. As always, a copy of the slides will be emailed to you after the webinar is over. And I do have to let you know that this webinar is being recorded and will be available on the Maryland Apex Accelerator website and YouTube channel. For those of you who are not familiar with the Maryland Apex Accelerator, it's our mission to help Maryland businesses compete in federal, state and local government procurement processes. Our services are no cost to you. So if you are interested in receiving assistance, please register on our website. Okay, well, that's enough for me. Good morning, Richard and Adam. The floor is yours.
Good morning, Yasmin, and thank you so much. And thanks, Yasmin, for everything you and your team at the Apex Accelerator do to bring terrific content to small businesses in the area. We really appreciate the opportunity to present to you, or to present to your members again. And thank you, everyone on the webinar, for joining this morning. I'm Richard Arnholt. As Yasmin mentioned, I'm a member of the government contracts practice at Bass, Berry and Sims. For those of you who are not familiar with our firm, we're a full-service law firm with over 300 attorneys, and our clients in the government contract space include public and private businesses, ranging from small and emerging businesses to Fortune 500 companies with complex government contracting issues. I'm delighted to be joined today by my colleague and associate, Adam Briscoe, who is also a member of our DC-based government contracts practice. Today, we are going to cover some of the key topics in the small business and DoD mentor protege programs, including the opportunities to develop joint ventures between mentors and proteges. And then we're briefly going to cover the small business size protest process at the end. As Yasmin mentioned, if you have questions, please put them in the chat box. We'll do our best to get to them during the presentation. If we run out of time our contact information is also included on the slides. Please feel free to reach out to us at any time after the presentation's over, and we will be happy to help. So first, the SBA Mentor Protege Program. This program, also called the All Small Mentor Protege Program, was established to provide small businesses with an opportunity to enhance their capabilities and improve abilities to compete for federal contracts. The All Small program really is a reflection of the fact that our government, per congressional demands, is attempting to spend 20%, 30%, and with regard to some agencies, 50 or 70% of its prime contract dollars with small businesses. And the small business community, in some respects, lacks the capacity to digest that small business contract spend. And so the SBA has developed a program to allow large businesses to provide additional support to small businesses to perform the work to meet those goals. And I just looked recently at the 2024 prime contract small business goals that the SBA has set out for this year. For DOD, it's 22.43%. For the Department of Homeland Security, 36%. Department of Interior, 53%. For the SBA, their goal of small business prime contract awards is 70%. So really a tremendous amount of opportunity out there for small businesses. And the programs we're going to cover today really give you a chance to build your capacity to take on that work. This All Small Mentor Protege program requires that agreements be approved by the SBA. and the SBA's approval makes that agreement valid for all participating agencies except for the DOD's Mentor Protege program, which Adam's going to cover in a few minutes. As of June 2024, there are over 1,800 SBA-approved Mentor Protege agreements. The list is publicly available, and you can go on the SBA's website to take a look and see which companies are participating in the program. There are a number of benefits of the Mentor Protege program. From the small business's perspective, it gives the protege an opportunity to expand their capacity and bid independently. They're allowed to get management and technical assistance from their mentor, building out their internal processes. They're able to get financial assistance from a mentor, whether that be equity or loans. They can receive contracting assistance, trade assistance, business development assistance, and general administrative assistance as the small business builds out their operation. And along with the other benefits that are covered on the slide, the really key thing to remember is that all these benefits can be provided without affiliation concern. Typically, if a small business's relationship with another business is too close, if the businesses are intertwined, the small business may find those two businesses to be affiliated such that for purposes of determining the size of the small business, both businesses' revenue or employees will count towards the North American industry, the North American industry classification standard. And that could result in the business not being small for the purposes of a particular set-aside. So the ability to provide these benefits without affiliation concerns is really key. The protege could also win subcontract awards from the mentor. And one of the key benefits we'll cover in some detail today is the ability of the protege and the mentor to form a joint venture that qualifies as a small business. If, for example, the protege and the mentor-protege relationship is a hub zone small business, the mentor and the protege can together form a joint venture and compete for hub zone set-asides. The JV carries the certifications of the protege. In addition, there have been some recent changes to the regulations, and it's become clear now that the joint venture can carry on the past performance or use the past performance both of the JV and of the mentor and the protege when it's competing for work. The SBA's All Small Mentor Protege program sort of grew out of the original Mentor Protege program on the SBA side, and that was just for 8A, small disadvantaged businesses. Subsequently, the SBA created an All Small program, but for a short time, they also maintained the 8A program. But in November 2020, the two programs were merged. And as I mentioned earlier, proteges are eligible to form a joint venture with the SBA approved mentor. That was a feature of the old 8A program as well. But the new All Small program has simplified that in a number of respects. So what are the eligibility requirements for this program? Can any small business participate? Yes, you have to be a small bit for the protege. You have to be a small business under primary or secondary NAICS code with industry experience. And you have to identify a mentor prior to applying for the mentor protege program. The SBA does not serve as a matchmaker, so you need to come to the SBA with your proposed mentor and submit that draft mentor protege agreement for review and approval. The mentor can be any size business with ability to assist the small business. It can be a small business or a large business. Also, mentors companies can simultaneously be mentors and proteges because you can be a small business as a mentor. The mentor has to possess good character and not be suspended or debarred. And for those of you not familiar with suspension or debarment, that's an administrative exclusion from the government marketplace. So the SBA will confirm before approving a mentor-protege agreement that the mentor is not at the time suspended or debarred. Both the protege and the mentor have to be registered on sam.gov. They have to be organized for profit or as an agricultural cooperative. And the businesses cannot be affiliated at the time of application or for reasons other than the mentor-protege agreement. So, for example, if you set up you have a small business that you're operating and your wife sets up a small business and you attempt to enter into a mentor-protege agreement with your wife's small business, the SBA may have some concerns. there's a significant chance those two businesses will be found to be affiliated. In fact, the SBA regs create a rebuttable presumption that a business owned by your spouse is an affiliate of your business. So something to keep in mind, once you've identified the potential mentor, obviously you need to make sure the two businesses aren't so closely intertwined as to be considered affiliates. So the application requirements. The mentor-protege agreement has to identify specific forms of assistance, when, why, and how. Consistency with the protege's business plan is important. You would apply on certified at SBA.gov, and you have to complete a short mentor-protege online tutorial and submit with your application a certificate of completion of that tutorial, along with the executed mentor-protege agreement. The processing time takes about 100 days. The SBA, I believe, still has a template of the mentor-protege agreement online, but obviously some tailoring of that template needs to be done. As I mentioned earlier, the mentor-protege agreement has to be consistent with the protege's business plan, and it has to set out in some detail the type of support the mentor is going to provide. There are some annual reporting requirements into this program, and the SBA will hold the mentor to its obligations under the mentor-protege agreement. There are some potentially serious consequences for not complying with the agreement for a mentor. A mentor-protege agreement can last for up to 6 years from the date of SBA approval. As I mentioned, there are annual evaluations and reporting obligations. A protege can have up to 2 mentors at a time, but no more than 2 over the life of the business. And mentors can have up to 3 proteges at a time. Recently, the SBA confirmed that a mentor's corporate family can exceed the 3 allowed proteges if that number going over that number results from an acquisition, and the purchasing mentor commits to honoring all the obligations under the seller's mentor-protege agreement. Another, I think, important thing to remember that is sometimes overlooked in these mentor-protege arrangements is that a protege firm can agree to sell or otherwise convey to the mentor an equity interest of up to 40% in the protege firm in order to raise capital. This is a terrific opportunity because typically, if a large business or another business owned 40% of a small business and there were other connections with regard to support the large businesses providing to the small business, they would almost certainly be found to be affiliated. That may result in that small business no longer being eligible to compete for set-asides. But under this program, the large business can own 40% of the equity in the protege, injecting much needed capital potentially. And with that, I'll turn it over to Adam to cover the DoD Mentor Protege Program overview.
Thank you, Richard. Hello, everybody. It's a pleasure being with you today. And as Richard mentioned earlier, my name's Adam Briscoe. I'm an associate in Bassberry and Sims's government contract practice. So now let's take a look at one of the more popular agency-specific mentor-protege programs, the Department of Defense Mentor-Protege Program. Richard, you can move to the next slide, please. Great. So this agency-specific mentor-protege program with the Department of Defense was established in 1990 as a pilot program during the first Gulf War, and it is currently the oldest continuously operating federal mentor-protege program. And in fact, just recently in March 2024, DOD issued a final rule which permanently authorized this program, meaning that it no longer needs to seek temporary reauthorizations each cycle. Next slide, please. So when looking at the purpose of the DoD specific mentor-protege program, it is ultimately to provide incentives for DoD contractors to assist protege firms or small businesses in enhancing their capabilities and to increase their participation in the defense industrial base and ultimately compete for small business contracts. As we know, breaking into a new market such as the Department of Defense contracting market can be quite difficult, and so this program provides a vehicle for those small firms to break in with the assistance of a more seasoned DoD contractor. Next slide, please. So when looking at the types of DoD mentor-protege agreements, there are kind of three unique agreements. The first is a reimbursable mentor-protege agreement. And under this agreement, the mentor business can receive reimbursements for allowable mentoring expenses up to $1 million a year for up to 3 years, which is the maximum term of a DoD mentor-protege agreement. As we'll get into the next slide, they generally carry a 2-year term, which can be extended for 1 additional year. So this reimbursable type of agreement basically allows that mentor company to seek reimbursements for the costs that they incur during the course of the agreement. The second is a credit type agreement, and this can also be quite valuable for a large DoD business, where the mentor ultimately receives credit towards their small business subcontracting goals using any socioeconomic category of the protege. And the key here is that you get a multiplier effect on that, on the credit you get towards the subcontracting goal. So a pretty nice incentive for large DoD contractors who have specific small business subcontracting goals on their prime contracts. The third is a kind of a unique hybrid type agreement, where in the first year, the mentor receives credit towards their small business subcontracting goals. And then the second year of that mentor-protege arrangement, the large business mentor receives reimbursements for the mentoring expenses. Next slide, please. So to apply for the program, similar to the SBA program, a company must either seek out a mentor or be sought out by a large business as a protege. DoD, also similar to the SBA, doesn't act as a matchmaker, and so you must approach the DoD with your proposed arrangement, the mentor and protege identified. And one thing I like to note here is that it's recommended to do detailed due diligence of the company you're seeking out, either as a mentor or as a protege, to understand their contracting experience and any kind of opportunities that they see upcoming down the pipeline for them, because ultimately it's a multi-year partnership with this other company, and difficult to break out of once you enter it. So once that relationship is identified, those company, either the mentor or protege is identified, then either the applying company, either the mentor or the protege, must identify a major buying command that will sponsor the mentor-protege agreement. Next, the mentor specifically must apply to DoD's Office of Small Business Programs to become a qualified mentor. And that's one thing that's unique about the DoD program as opposed to SBA, is that DoD maintains a kind of a roster of qualified mentors. And so the mentors must apply separately and independently of the mentor-protege unit to DoD to become that a qualified mentor, qualified and recognized mentor. Finally, the parties must execute a mentor-protege agreement, which contains a number of certifications required by DoD. And similar to SBA, DoD provides a kind of template mentor-protege agreement, which will, in most cases, need to be tailored for the specific agreement. Next slide, please. So now once the agreement is executed, it should be submitted to the major buying command, for review and endorsement for this specific type of agreement chosen, as we reviewed previously, either the reimbursement, credit, or the hybrid. Then DoD's Office of Small Business Programs will provide a preliminary assessment of the Protégé's cybersecurity readiness. So that's something to kind of take away from this presentation. And generally speaking, the DoD has been very focused on cybersecurity regulation and cybersecurity readiness in the past five to 10 years. And so any companies looking to enter one of these agreements should have cybersecurity front of mind as well. And so although going to the final point on this slide, although it's not an application requirement, it's important to keep in mind that during the term of the mentor-protege agreement, DoD is authorized to terminate it for convenience, as it would for any other prime contract that DoD would have with another contractor, individual contractor. Next slide, please. So diving into some more procedural details of the program, any approved DoD mentor-protege agreement has a 2-year term unless approval is given for one additional year. I touched on this a few slides ago. So in total, the DoD mentor-protege program for any specific mentor-protege agreement would last a maximum of 3 years. Both the mentor and the protege must report on the progress made under the agreement on a semi-annual basis. And it is important to know that proteges are required to provide data on their company for 2 years following the expiration of the agreement itself. And this is most likely for DoD to understand how the protege has developed and hopefully grown as a result of its experience with the DoD Mentor Protege program. And in the last point here is basically just similar to the SBA timing point we made. Generally, the processing time for the Office of Small Business Programs and for the Major Buying Command would be approximately 10 business days upon submission. And so at this point, I will turn it back to Richard to walk us through the actual formation of joint ventures.
Thank you very much, Adam. Appreciate it. As Adam mentioned, we're going to cover I think one of the most interesting and most beneficial features of the All Small program, the SBA's All Small program now, and that is the ability of mentors and proteges to together form joint ventures to compete for small business set-aside work. As mentioned, a mentor and a protege can form a JV that qualifies as a small business for any federal government contract or subcontract, provided that the protege qualifies as small for the size standard assigned to the contract. Large primes, as the audience may be familiar, are required to establish small business subcontracting goals if the contract is over, I believe the threshold is $750,000. A source of potential business for these joint ventures or for small businesses more generally isn't just the federal government with set-aside programs, but also larger government contractors that are working to satisfy those small business set-aside obligations. These joint ventures are really the only opportunity for, under the SBA's All Small program, are really the only opportunity for non-small businesses to share a prime contract role in work that is set aside for small businesses. And just here's a graphic of what this looks like. The mentor and the protege that would enter into their mentor-protege agreement first and be approved by the SBA. Then they would set up a joint venture that would qualify as small under the Small Business Proteges NAICS code, and could then go after that JV could then go after set-aside work. So what are some of the advantages of these JVs? As I said, the newly established company can go after these set-aside contracts. It can cover multiple solicitations and contracts. The JV doesn't have to be set up just for one opportunity. can benefit from the combined bonding capacity of its member companies. If you set up a new legal entity, which is typically what we recommend to clients, the liability can be limited to that entity. The entities can avoid the high cost structure of member companies if you've got a high G&A rate. For example, the performance history combines that of each member, which can be really beneficial given the importance of past performance in a number of evaluations. Small businesses can be more competitive as a prime contractor under this type of arrangement. And as I suggested earlier, past performance of the JV in each member can be considered. There are some disadvantages. It's not all great news. And maybe concerns regarding responsibility for contract performance or non-performance. Every member of the JV needs to speak as one, and we're going to talk in a little bit more detail in a few minutes. Adam's going to cover some of the specific requirements, but the small business protege has to own a majority of the joint venture, which can be challenging sometimes for large businesses that are in the mentoring role. It's possible for one member to get less work than it would as a sub or a single prime. This can be more expensive to set up due to the paperwork required. Setting up a new company, there's some cost associated with that. It's fairly modest now, given how easy it is to set up, for example, a limited liability company, an LLC, in Delaware or some of these other more business-friendly states. Liabilities are shared by all members. And an important point to make here is that the JVs may be harder to exit than the standard sort of prime sub relationship if they don't work, which is why we really recommend that before companies look at forming mentor protege agreements, they make sure that they have a relationship between the two, and they are confident that mentor protege agreement is going to be beneficial to both of them. I sometimes analogize the mentor protege arrangement to sort of like a marriage. And you want to make sure the companies have dated for some time before they take that next step. With that, Adam is going to cover some more details of the mentor protege JV process.
Thank you, Richard. So now jumping into kind of the steps for getting a mentor protege JV set up and running. We basically, the first step is to get SBA to approve the mentor protege agreement. And Richard walked through those steps earlier. The next step would be to actually form the joint venture with the relevant Secretary of State and enter into a joint venture agreement. And as we'll go into some detail in the next few slides, there's specific information and requirements that need to be inside the joint venture agreement. The next step is to then ultimately prepare and submit an offer on a set-aside contract, on a small business set-aside contract. Now, contrary to some people's belief, there is no requirement to have the certification of compliance when submitting an offer on a set-aside contract. Actually, the SBA regulations specifically state that the JV certification of compliance is only required to be submitted to the contracting officer and SBA prior to performance. So it can be following the award of a contract and prior to performance beginning. Next slide, please.
And Adam, if you don't mind, just one quick point here. I mean, it's positive, I think, that you don't have to get all small JVs approved by the SBA in almost all cases prior to the JV competing for work. The downside is, however, if your joint venture agreement doesn't include all the requirements that Adam is going to talk about in a little more detail, it may leave you vulnerable to a potential protest, and you could invest a significant amount of money pursuing that work, putting the JV in place, only to have it taken from you, only to lose that opportunity if there's a successful size protest later on, because your joint venture agreement missed some of the mandatory requirements.
Thanks for that, Richard. So looking into kind of JV past performance and how it's treated, it's not unusual for a small business joint venture, such as one formed by mentor and protege, to lack prior experience examples performed by the JV itself, if you're creating a brand new entity, which is why the SBA regulations specifically allow for experience or past performance of the underlying members of the JV to be considered on behalf of the JV when it bids on an opportunity, on a contracting opportunity. Similarly, this is why SBA's regulations direct agencies to evaluate JV experience in the aggregate, meaning that both the members of the JV entity, and the JV entity itself. When obtaining past performance ratings from past work as part of a JV, small business contractors can either use the past performance rating for work done as part of a joint venture, or they can use the past performance rating for work done as use the past performance rating for work done as a small business contractor. And so this gives the small business contractor flexibility as far as how it wants its past performance to be treated and ultimately used on future contracting opportunities. Jumping in now here into the kind of purpose, the SBA's guidance on joint ventures and what is required as part of the joint venture agreement itself. These points here basically mirror the SBA regulations as to what information is required to be included in the joint venture agreement. So number one, the first is the purpose of the JV is a required information to be included in that joint venture agreement. The protege must be identified as the managing venture, or the project manager must be an employee of that protege firm. As Richard mentioned earlier, the protege must own a majority of the JV entity and must be a legally separate entity. The JV also must have a separate bank account that requires signatures by all parties, a member to the JV, for withdrawals. And each party's responsibilities regarding contract negotiations, labor sourcing, and performance are kind of each party to the JV is responsible for each of those separately. Now, an important last point there noted is that the protege only receives profits commensurate with the work it performs and not the ownership that it has in the JV. And we'll get into the kind of ownership and work performance splits and requirements here shortly. So this slide here kind of mimics again the information we just went through on the past slide. Again, the JV agreement must be in writing, specifies members' responsibilities, itemizes the resources, and separately identifies a JV bank account. And the role of the protege, as I mentioned, is the managing venture of the JV, and the employee is project manager for contract performance. And just finally there, the protege must maintain all administrative and accounting records. Thanks, Richard. So now just diving into the work share restriction. This is quite an important point, which kind of limits and has a number of reporting requirements related to the individual work that mentors and proteges undergo as part of these agreements. So specifically for the performance of work requirements within the JV, the protege must perform at least 40% of the work that the JV intends to perform under a contract without the assistance from a similarly situated small business. And the work that the protege does must be more than administrative or ministerial in nature. And we'll get more into the splits as well when we get into limitation of subcontracting here below. This is a second kind of key consideration, which limits the percentage of work that can be delegated to subcontractors under a contract awarded to a mentor-protege joint venture. So as you can see there, for specific types of work, so for service contracts, no more of 50% of the contract's revenue can be subcontracted, and similar for supplies or products. For construction projects, no more than 85% can be subcontracted, and specialty trade construction, no more than 75% can be subcontracted. So ultimately, you know, the limitation of the percentage, the limitation of subcontracting fluctuates based on the type of work. And as highlighted below, for an example, in the case of a services contract, the JV must perform 50% of the work, as I noted just a second ago, of which the protege must perform at least 20%, which is 40% of the 50% that the JV is undertaking. And the mentor can do up to 30% of that work, which represents 60% of the 50% that the JV is undertaking. And the remainder, the remaining 50% under a services contract can be subcontracted to an outside firm. Rich, we can go to the next slide. So now getting into reporting and other certifications. As I mentioned previously, during the kind of formation phase of the JV, the certificate of compliance with the JV agreement requirements is necessary. And as I mentioned, that certificate of compliance is not required upon the time of bidding, but is instead required prior to performance. Similarly, performance of work reports are required on a regular basis, and those typically beyond a certification will actually require some reporting on revenue numbers to the SBA, so the SBA can monitor and ensure that that 40-60 split, as I mentioned, on the performance of work is being complied with by the joint venture. Additionally, there are financial reporting requirements that are due on a regular basis to the SBA. These miscellaneous points are also generally required to be outlined in the joint venture agreement, which include the itemization of all major equipment, facilities, and resources furnished by each party, and obligates all parties to finish the contract whether one party withdraws from the agreement. And so that may be added to the list of the potential disadvantages of a joint venture, is that if a party withdraws, the other entity is on the hook to complete performance of the contract. Next slide, please. So just diving into the reporting aspect of a joint venture, a mentor-protege joint venture. So regular reporting to SBA is key, and a key kind of element to joint ventures. Specifically, there are quarterly and project end financial reports due to SBA. And as I mentioned previously, performance of work reports, which we'll go into more detail in a minute, are due on an annual and project end basis. But the kind of carve out here, the exception is that small business set aside contracts only need to submit performance of work reports. They do not need to submit financial reports. But as you see here below on the financial information and performance of works are required for 8A Hub Zone, service disabled veterans, small businesses, and women-owned small businesses, mentor protege joint ventures. Next slide, please. So as for the ownership structure and profits, the protege must own at least 51% of the JV entity or equity in the JV entity, and the JV entity itself should be unpopulated. And then as for the profit splits, the profits follow the percentage of work completed under the contract, not ownership percentages. And so for the percentage of work requirements under the SBA regulations, the protege must perform at least 40% of substantive work on any awarded contract. Next slide, please, Richard. And so this diagram kind of walks us through those differences. It can be kind of confusing to hear verbally. Maybe this visual provides some assistance. You can see at the top there, while the legal entity ownership would be split, you know, at minimum, the protege owning 51% and the mentor owning 49%. Then contract performance under the performance of work requirements jumps to that 40-60 split, with the protege required to complete 40% of the work. And then to the right there, the profits under the contract follow the contract performance splits. So when the protege performs for at least 40% of the work, it will be entitled to 40% of the profits under that contract. And so now I'll turn it back to Richard for some more ownership details and small business protests.
Thank you very much, Adam. Appreciate it. Here's just another graphic that we thought is helpful about the process. Again, find a partner, perform due diligence, submit your application, do the JV agreement, your JV certification of compliance, all the points that Adam covered. Now, be aware of the reporting requirements for mentor protege. You've got annual requirements, end of relationship requirements for the JV, quarterly for some set asides, project end, and annual. Joint ventures and set aside, we're going to want to cover a couple of important details here. There is a special requirement for joint ventures with small businesses bidding on set asides. If you set up a JV, that limited purpose entity to bid on specific set aside opportunities used to be subject to what was called the 3-in-2 rule. And that meant that you could pursue, you could win 3 contracts in a 2-year period, and that was it. They capped the number of opportunities your purpose-built JV could win. In 2020, the 3 contract limitation was eliminated, but the life of the JV is still, or the time during which the JV can pursue small business set-asides is still capped at 2 years from the date of the first set-aside award. Now, you can establish multiple joint ventures with between a mentor and a protege. So this restriction, I don't know how much sense this limitation makes in light of the fact that you could establish additional JVs, but it's important to keep in mind that it does. There were some changes to the FAR fairly recently to clarify that the joint ventures under this all small program were to be treated as small. First, a JV can qualify as small in one of 2 different circumstances. The first, that we haven't really covered in this presentation, is that each party to the joint venture qualifies as small under the size standard for that solicitation. Right, so if both 2 small businesses under a NAICS code that has a $25 million 5-year revenue, average revenue size limit, if both those business qualify as small, they can form a JV and pursue work under that size standard. The second is what we've talked about today, that the protege is small under the applicable size standard for the solicitation, and the joint JV is comprised of a mentor and a protege with an approved MPA under the SBA's mentor protege program. Similarly, JV qualification requirements for a socioeconomic program, so a women-owned small business set aside, a JV can qualify for one of those programs if two things are true: that it qualifies as a small business JV under the standards that I just went over, and one of the JV parties meets the requirement for the socioeconomic program. There were also some adjustments in the past few years to regulations applicable to hub zones and to women-owned small businesses. For hub zones, hub zone entities have to be certified annually by the SBA and remain eligible for hub zone contracts for that entire year. Contractors operating above hub zone entities are now required to verify their hub zone subcontractors are certified with the SBA. Previously, I believe that a contractor was entitled to rely on a claim of hub zone status by a subcontractor. And now that the higher tier subcontractor that's using that hub zone small business towards meeting its small business subcontracting goals has to actually confirm its status. Also, contracting officers are now allowed to award contracts to hub zone entities as set-asides and sole source contracts at or below the simplified acquisition threshold, and that's typically $250,000. For women-owned small businesses, for that program, women-owned small business concerns have to certify with the SBA or an SBA-approved third-party certifier. But for awards outside of the women-owned small business program, women-owned small business concerns can continue to self-certify. So now, as I said, we're going to just briefly go over the small business size protest process and then talk about some sort of other some protest issues in the joint venture world. So for a small business set aside, the government has set up some important sort of safeguards that allow a concerned party to challenge a proposed award to a small business. An offeror can challenge. So let's say you competed for a small business set aside award, and a company that you believe to have long outgrown the NAICS code size standard, whether it be employee based or revenue based, as the putative awardee. You got a letter saying we intend to award to company X that you know to no longer be small. You have the ability to file a size protest. The contracting officer, if he or she believes the putative awardee is not really small, can file a size protest. The SBA can challenge the proposed award, or any other interested party. There's a very, very short timeline to file a size protest with the SBA. It has to be filed within 5 business days after notification of the apparent awardee. So when competing for a small business set aside, we really recommend to clients that they think about potential protest strategy early on, even in advance of getting notice of the putative awardee. And think about things like, if this contract is, if the government intends to make an award to a company other than my company, am I going to protest? And if the answer to that question is probably, it would be worthwhile to think about your competitors, if you know who they are, for that opportunity, and whether any of them may be close to the threshold for the relevant size standard, and try to gather some information prior to that 5-day clock beginning. So what happens if your company gets protested? Let's say you are an agency has announced that your company is the apparent awardee, and you get a letter from the SBA requesting a tremendous amount of information on Form 355, tax information, financial information, information about your company's relationships with other companies, and so on. We advise you very strongly to get counsel to assist with that response, because not filing your response could result in the SBA reaching the presumption that you are not small, that the things said in the protest are true. And answering the SBA's requests, particularly on Form 355, incorrectly could jeopardize your award. So, whether it's our firm or another, I highly recommend that you engage counsel who specializes in government contract work if your company has an award that's protested at the SBA. So the process here is a little bit different than the process for filing a bid protest, which can be filed where the government's made an award to another company and you think that award is improper. Those bid protests, are filed with the GAO, the Government Accountability Office, or the Court of Federal Claims. These size protests are handled by the SBA, and the initial level of protests are handled by what's called the area office, it's an administrative review. And the process is filed with the contracting officer. The contracting officer then forwards it to the SBA, and then the area office, which has cognizance over a certain geographical region of the country, issues a size determination. If you believe that size determination is wrong, there is an opportunity for review and appeal of size determinations, and that's done by the Office of Hearings and Appeals at the SBA, or OHA. Just a couple more points on mentor-protege JV potential protests. As we've talked about during the presentation today, companies can be found affiliated based on some of the support that we've talked about: financial support, technical support, issuing a number of subcontracts to a small business. All these things could result in a finding of affiliation unless an exception to those affiliation rules apply. And the two ones that we covered today are each partner in a joint venture is itself small under the relevant NAICS code, or there is a current mentor-protege agreement approved by the SBA, and under that mentor-protege agreement, you have entered into a joint venture agreement that satisfies all the SBA's regulations requirements. So a size protest could challenge the contents of the agreement. If your joint venture agreement, and I mentioned this earlier during, while Adam was discussing these joint venture agreements, if your agreement misses some of the mandatory language that the SBA set out in its regs, it could be found invalid, and you might lose a putative award to your joint venture because of that. So these are often challenged. They are frequently the subject of size protests. And it's all the more important because these JVs are not approved by the SBA prior to contract award, that you ensure your agreement meets the regulatory requirements. Again, whether it's our firm or another, it's I think a prudent thing to do to engage counsel to assist with confirming your JV meets those requirements prior to investing a lot of money and pursuing a contract opportunity. Prior SBA approval is required for sole source 8A contracts for JV agreements. That's one of the rare exceptions. And the important point here is that the SBA Office of Hearings Appeals has confirmed that once a mentor-protege agreement is signed, competitors can't use the size protest to challenge the mentor-protege agreement. So if the type of support a mentor is providing to its protege is part of the scope of support that it agreed to provide under the mentor-protege agreement, that cannot be the basis to assert that the two companies are affiliated. There may be other things the mentor is doing to support the protege that are outside the scope of the mentor-protege agreement, and that's that could be a valid challenge. And if there are affiliation concerns that weren't disclosed to the SBA in the mentor-protege agreement application process, those could be an issue at OHA. But the substance of the mentor-protege agreement, the actual support that you commit to provide in that agreement, cannot result in a finding of affiliation. So obviously the protest process can be complicated and there are a lot more issues to consider in it, but we wanted to give you just a brief overview of that. And now if you have any questions, please feel free to put them in the chat. And we've been trying to answer your questions as we've been going along today. I did post a link to the active mentor-protege agreements. And I also posted a link to the mentor-protege template agreement. Let's see, I see a question here. Does the SBA have or would be able to rate the mentors and their past performance on working with their proteges in the past? I don't think the SBA does that in any public way. I think they probably confirm that the mentor is providing the support they committed to provide in the mentor-protege agreement when they review the reports that are required to be submitted to the SBA. And as I said, if a mentor enters into a mentor-protege agreement and then sort of abandons its protege, there could be negative consequences for the mentor. But I don't believe the SBA makes any of that public. There's also another question here, and Adam, I'll let you handle that if you don't mind. The question is, what are the benefits of this program to the mentor? And there's also, I think the same person has said they can't find solicitations for this program. Do you mind covering the potential benefits to the mentor, Adam?
Yeah, sure. So ultimately, I think the largest benefit would be in the case of a large business mentor, where basically through the mentor-protege program and forming a joint venture under the mentor-protege program, that mentor can benefit from the size status of a small business protege. And so ultimately that JV, for purposes of the time period that the joint venture is active and the mentor-protege agreement is active, that JV can bid on small business set-asides. So ultimately that meant large, or other than small mentor business, can benefit from the small business size status of its protege. Apologies. So that's kind of, I think, the number one advantage, the kind of the one that jumps out front of mind. Additional advantages in the case of a all small joint venture where both the mentor and protege are small businesses. I think the key benefit there is that you have double the resources, double the capabilities, potentially double the manpower to successfully perform under a small business contract. Those are kind of the two that jump out to me, Richard.
That's great. Thank you, Adam. I totally agree. Also, under an approved mentor-protege agreement, the mentor has the ability to acquire up to 40% of the equity of the small business, and to then form a JV with that small business and then compete for set-asides. In the absence of the mentor-protege agreement, that would almost certainly result in a finding of affiliation between the mentor and the protege. That would mean the protege or JVs between the mentor or between the large business mentor and the small business protege were not eligible for small business set-aside work. So this is really a way to allow mentors to profit from, or large business mentors to profit from work that's set aside for small businesses, with the understanding that the mentors in exchange are going to inject capacity into the small business community. And with regard to this, the comment that you couldn't find solicitations for the program, just to be clear, a joint venture formed under the SBA's All Small Mentor Protege program can compete for any government contract, right? There are not solicitations specifically for SBA Mentor Protege, for the SBA Mentor Protege program. You can compete for full and open contracts. The real benefit, as we've talked about through the presentation today, is that JV formed under the Mentor Protege program can compete for a small business set-aside as long as the set-aside is as long as the protege meets the NAICS code requirements. So yes, the follow-up comment, yes, absolutely, I agree. So you'd be looking for small business set-asides mainly, then the mentor to get the benefit, and the small business's benefit, the Protégé's benefit, is the large business can inject capital and can assist with business know-how and so on, to bolster the small business's capacity and allow it to compete for work and win work that it otherwise would not be able to win, and can accelerate the growth path for small businesses without the small business risking a finding of affiliation. With regard to the comment that it's wise to steer clear of joint venture, mentor-protege, JV relations, and the small business loses out, I would disagree with that comment. As I just said, I think small businesses often need assistance building out their business systems, policies, and procedures, and sometimes can be challenged to get capital needed for expansion or to pursue opportunities. And the Mentor Protege program enables large businesses to inject that knowledge and to sometimes inject capital directly to give small businesses greater opportunity. Also, a very important point, when pursuing small business set-aside work, sometimes a limiting factor for newly established companies is their lack of past performance. Under the Mentor Protege program, joint ventures will carry with them the past performance of the JV itself, but also the past performance of the mentor and the protege. So it could significantly, entering into a mentor protege joint venture could significantly increase a small business opportunity to win work. And the mentor, following comment, the mentor could potentially own 40% of the small business, but that's certainly not required. It just, the mentor protege rules state that a mentor can own up to 40% of the small business, inject capital into the small business in exchange for equity without a finding of affiliation. So that's, I think, an important thing to keep in mind. And in fact, most of the mentor protege agreements that we've assisted clients with, the large business mentor or even the small business mentors don't owe any percentage of the protege, but it is an opportunity. And there was a question about, I apologize, Yasmin, for going over. I just want, if you don't mind, we'll just get one or two more of these. Where can we find a list of mentors for DOD? Adam, is that a list publicly available? You mentioned the DOD actually screens companies and confirms that they can be mentors.
Correct. Yeah, that list is publicly available on DOD's Office of Small Business Programs website.
Terrific, thank you. And then for the small business, all small mentor protege program, there is no list of approved mentors. We recommend that if there's a company that you work closely with, that you can discuss that with the company and see if it's appropriate for your business. And then finally, would recommend the mentor protege program and joint ventures. I think it provides tremendous opportunity both for small businesses and for large businesses. It's not going to be a perfect solution or a perfect program for every company, but there are certainly opportunities here, and the chance to get this type of support from a large business mentor without a finding of affiliation could accelerate a small business's growth. So I think, yeah, it's a great opportunity there, and great opportunity for large businesses as well. If they don't fully understand, their chance to compete with a small business as a joint venture, I think once they see this, gives them an opportunity to profit from small business set-asides as well in exchange for providing that support. It can raise a lot of interest. And I believe that Yasmin's going to be circulating a copy of the slide deck today. Adam, my contact information is available at the end of that presentation if there are any questions that you had today that we weren't able to cover. But I really appreciate everyone joining today. And again, Yasmin, thank you so much to you and your team for allowing Adam and I to present.
Thank you so much, Richard. Thanks, Adam, for a wonderful presentation. And thank you all for your great questions and for participating today. As Richard said, I will be sending out the slides and the recording shortly. And we will hopefully have Adam and Richard or either of them back later this year to teach some more classes for you, because they do such an excellent job. We really appreciate it. So thanks again to our presenters and thank you all. You stay safe out there and we'll hope to see you at another Apex Accelerator event. Thanks everyone. Bye-bye.